Mr. Deputy Speaker. The Austria bill is timely. I've met with residents affected by online harms, and Singaporeans have written to me asking for reforms. From how we stay in touch to how we work, shop, learn, and govern, the internet has evolved into more than just a means of communication. It has become a second life, and the divide between the online and offline worlds continue to blur as technology becomes increasingly interwoven into our daily lives. All laws need to keep pace with modern-day advances and the threat of today. The recent report by SG Her Empowerment, 404 Help Not Found, lived experiences of online harm survivors, shed light on the harsh realities that defines today's digital landscape. Let me share a story of one of the online harm survivors mentioned in the report. As a child, Zain experienced bullying in school. His peers took to online platforms weekly to spread negative remarks about him. Later in life, during his polytechnic years, Zain experienced doxing. The perpetrator shared his name, school, and course on Twitter and threatened Zain. These incidents had an impact on Zain in his growing years. He kept his pain to himself, fearing retaliation and judgment. The emotional toll eventually caught up with him. During his national service days, Zain experienced panic attacks and had to seek professional help. Zain's journey reflects how cumulative online harms can leave deep psychological scars, one that lingers long after the screen goes dark. And what happened to Zain isn't rare. It is a glimpse into a culture where online harm has become casual, even accepted, where cruelty hides behind screens and victims often suffer in silence, many times too afraid, too tired, and too ashamed to seek help. It is important for us to be deliberate in shaping the tone of our online world for our children, our friends, and our neighbors, because the wounds may be invisible, but they are real and they last. This bill is a step in the right direction. The OSC is vested with the authority to issue directions and orders to online service providers, communicators, and administrators. Additionally, victims can turn to civil recourse and remedies for redress. In the age of AI, where false and harmful content can spread faster and cut deeper, such protections have never been more important. The youth, in particular, are particularly and especially vulnerable to online harms. To find out what the youth thought about the bill, I spoke with Youth Tech SG, formerly known as Cyber Youth Singapore. Youth Tech SG is a youth-led social movement and charity, and they help. One of their divisions is Youth Tech Institute, which focuses on helping young people navigate the risk and opportunities of technology, including online safety. They wrote to me and expressed their support for the bill, describing it as a signal for Singaporeans to foster a more cohesive, civil, and wholesome digital environment. They also welcomed the bill's introduction of new avenues for youth to seek help and relief when harmed online, options that previously did not exist. While the bill makes important strides in fostering a responsible digital environment, the online culture is ultimately one which requires users to build, and that endeavour goes beyond legislation. Having reviewed the bill, I find that the bill is a meaningful step forward. It is unlikely to be a quick or perfect fix, given how common online harms are and how deep-rooted they are in our daily lives. But it signals our shared commitment to build a kinder, safer Singapore, both offline and online. I support this bill and would like to share a few reflections and seek some clarifications. My first observation: the creation of the OSC and the scope of its enforcement powers is noteworthy. The speed of takedown is critical. While victims often suffer immediate harm, current means of redress are reportedly slow and sometimes ineffective. The IMDA's 2024 Online Safety Assessment Report found that major platforms acted appropriately only on half of the reported harmful content, often taking more than 5 days. The unfortunate reality is that victims are often left to navigate complex and sometimes opaque complaint processes, and structural challenges may further hinder platform responsiveness. The OSC played OSC plays a vital role in addressing these gaps. Its powers, such as issuing stop communication or restraining directions, enable victims to take timely and decisive steps to safeguard themselves. Moreover, Clause 26(1) provides that the Commissioner may issue a Part 5 direction if the OSC has reason to suspect that the online harmful activity was conducted. This allows OSC the flexibility to swiftly take down online harmful activity. I see that Australia had similar experiences from which we can draw some lessons. The Australian E-Safety Commissioner has the power to issue directives to address online harmful activities. Speaking at the 2023 symposium organized by MinLaw and SMU Yong Pang Hao School of Law, the E-Safety Commissioner from Australia highlighted the value of a dedicated and independent safety regulator in addressing online harms. In a Straits Times article, it was reported that she said, "Often, and I quote, often when people come to us, they want their images taken down. They don't want to be tethered to their former partner through litigation, which of course can take a long time. So what we provide is rapid assistance. I don't think we would have the same degree of success with the platforms, particularly where there are grey areas, if we didn't have these remedial powers." To this extent, I note that the there is a requirement for victims to first file a report to the online platform before approaching OSC. The duty imposed on the platforms also only starts when the report is accurately and properly filed to the platform. And therefore, the accessibility and ease of reporting on the platforms will be critical in ensuring access to justice for victims through OSC. I seek clarifications on how the ministries plan to work with the platforms to enable this. Secondly, I also seek clarification if the same content appears across different platforms and sites. How should the victim take action? Should the victim report all incidences he or she is aware of at the same time? Are OSC directions specific? Or will we land in a situation where the victim is required to repeatedly go through the process of reporting to the platform and then to OSC for each piece of material? Can a victim apply to OSC for the preemptive ban of similar materials resurfacing? Member Zulkarnain had mentioned the advantages that OSC offers in being a more responsive and less adversarial mechanism as compared to traditional litigation. I will not repeat that, but I stand in support of his point. My second observation is on anonymity. Victims of online harm may be reluctant to seek redress due to fear of repercussions, whether from the perpetrator, societal stigma, workplace consequences, or family pressures. This hesitation is particularly pronounced in cases involving intimate image abuse, doxing, or harassment, where the victim's identity is often central to the harm itself. I'm heartened to see that the Ministry has been sensitive to these issues. In respect of court proceedings, the bill envisages that the rules of courts may be amended to empower the court to order the redactation of identifying information, including parties' names, in court documents, to conduct proceedings in private, and to issue orders preventing the disclosures of parties' or witnesses' identities. I'm concerned that in practice, however, victims may remain vulnerable, and additional administrative steps may be required to secure their anonymity during the interim period before such orders are granted. I wish to suggest for the Minister's consideration whether a more victim-centric approach would be to introduce automatic redaction, subject to judicial discretion to lift such redaction where appropriate. This would mirror existing protections under the Children and Young Persons Act, CYPA, where proceedings involving minor are automatically anonymized, and the Women's Charter, which provides automatic identity protection in the form of prohibition of publication or broadcast of information identifying victims or witnesses. This would be especially helpful. This is applied under the Women's Charter in cases involving sexual offences. Extending automatic anonymity to victims of online harm, particularly those from vulnerable groups, would not only reduce procedural burdens, but also encourage victims to avail themselves to the options under this bill. Beyond the courtroom, I will be grateful for further clarity on how the ministry intends to safeguard the confidentiality of victims during the reporting process. Specifically, how will the ministry ensure that victims' personal information remains protected, while also upholding the rights of alleged perpetrators to be informed of the nature of the allegations made against them? My third observation relates to the new statutory tort of online instigation of disproportionate harm. Clause 87 of the bill introduces the tort of online instigation of disproportionate harm, which is designed to offer civil recourse to victims and their associates where public statements made in response to a victim's conduct are likely to incite others to act in ways that would cause harm to the victim. Civil action under this tort requires proof of actual or reasonably foreseeable loss or damage. While some heads of losses, such as financial losses, may be easier to prove, others, particularly psychological injury or emotional distress, have traditionally presented evidentiary challenges. I will be grateful for the Minister's clarification on how the latter cases will be treated. My fourth observation is that the bill seeks to address inauthentic material abuse, which is any audio, visual, or audiovisual material that has been digitally altered or generated that is false or misleading depiction of the victim's words, action, or conduct, but is realistic enough for a reasonable person would believe that the material emanated from the victim. In this regard, a depiction of a victim saying or engaging in anything includes a depiction of the victim's likeness saying or engaging in that thing. The bill would benefit from clarity on how likeness is assessed in the context of AI-generated content. For example, does resemblance alone suffice? Must there be an intent to impersonate or mislead? What evidentiary standards apply? In my view, these clarifications are especially important since resemblance may be subtle, stylized, or partial. In closing, Mr. Deputy Speaker, I welcome this bill. It is a timely and necessary step towards preventing the propagation of online harmful activities. This is especially important today when many of us, including young and old, spend much of our time online. The youths, in particular, are especially vulnerable to online harms, and I'm heartened that this bill provides additional avenues for their protection. In particular, I am encouraged by the Ministry's efforts to consult widely and engage with the youth while drafting this bill. The youth form a significant demographic that will be affected and protected by this bill. In their letter to me, Youth Tech Institute shared with me that they participated in the public consultation and dialogues organized by the government. They voiced their concerns and provided feedback on how the bill can continue to stay true to its policy goals without chilling legitimate online participation by youths. They tell me that their feedback was seriously taken in and considered. By participating in the drafting process of this legislation, our youth felt seen and heard, inspired and empowered. The youth had this to say, and I quote, "Thank you for showing us that policy can be made with us and not just for us." I'm grateful for the government for allowing the youth's voices to be heard on a bill that affect matters close to their hearts. I thank the ministers and their team for their efforts, and I'm happy to support this bill. Thank you.